And I assume that the extensive citations to Harvard Law School were an ode to your son. Actually, I found out later it's a friend of his. He's well done.
Hi,
Rich Cooper.
Greg Kerfman.
Good to meet you.
Probably only happened like initially.
Keith Morrison.
It's an order. Sure.
Dr. Maisel?
Yes.
Hi, Rich Cooper. Just
Hi,
want to say
Rich.
hello.
Nice to
Good to see you.
You read your brief and spectacular, beautiful, very clear.
I haven't had the benefit of
Yes.
seeing your statement, but to hear them.
Right.
Hi, Mr. Cooper, I think you remember the Senate Judiciary
Good
Committee.
to see you.
Dr. Hi, Claudine Homewash. Nice to see you.
That sounds great. Sorry, sir.
Take a seat. Do you need anything else? Comfortable? All right.
You make it all right, Bridget?
Tight.
Yeah, it is.
Sorry. Thank you very much.
Sure.
Hi. Nice to meet you. I'm Bridget.
Greg Kerfman. See you. So you're from Pennsylvania?
I am.
Is that right?
Yes. Where are you
Right.
from?
From Boston.
Oh, okay. And you're a doctor, I see.
Yes, yeah, from the New England Journal of Medicine.
Oh, okay.
So I work mostly on medical journals.
Okay.
Dr. Maisel is a vice cardiologist.
Oh, okay.
Knows a lot about these devices.
Okay. What, do you work for a hospital? Or? Oh, okay. Okay.
So you've done this before.
I did it last summer. I went to it before the Senate Judiciary Committee. So wouldn't sound very seasoned or anything like that. I'm
It's,
nervous.
it's a good place to start. Starting at the top it
I'm a
should
little
be
nervous.
easier. Yeah, yeah. Yeah.
Time it.
Well, we all are a little
Time it.
nervous,
Yeah.
but maybe David does this all the time. It's good that you're here.
Thank you. I appreciate you saying that.
Yeah, it'll help a lot. We just have to get some members of comments here. We'll be talking to ourselves.
Yes.
We can talk to ourselves. Uh-huh. Right. Yeah, right. Yeah. Yeah. You mean Dennis Quaid? Yeah. Oh, he was very good. Yeah. Really good.
Good to meet you.
Yeah, well, yeah. Yeah, right, thank you. Yeah, and to you. You'll be great. It's a nicely written statement.
It's so hard, you know. I think that
Yeah.
I think that makes it a little bit more difficult for me anyway.
Well, it's very compelling. I need to hear this. It's not, sometimes much more important than the legal part, which can get a little dry. Mr. Braley in front of us is on our side. He's very good. I expect him
So, Dr. Maisel, he's practicing.
Right.
I wonder if he knows my electrophysiologist. I'm curious to know, Dr. Joshua Cooper,
He probably would. I don't. What hospital?
University of Pennsylvania.
Uh-huh.
He,
Yeah, I'm
I
sure
think he
he-
lived in Boston for a while. He travels to Boston a lot, I know.
Yeah.
I wonder if, are they chatting? Yeah, he's chatting.
Yeah.
I didn't want to interrupt him, I couldn't tell.
And we'll ask him. I'm sure he must.
Yeah.
So have things settled down with the device?
I'm going to take it out.
Uh-huh.
So I'm going to have to get out of work like that. So my function went down. So
Uh-huh.
kind of right now I'm in limbo.
Yeah.
Not knowing what's going to happen.
Yeah. Well, it's been a tough road for you. So I hope it straightens out.
Thank you. Appreciate that.
You deserve it.
Thank you. Thank you.
I'll get his attention.
Piece in the paper.
You flew up this morning? Or did you?
I drove up.
Drove up?
Yeah.
Right.
Philadelphia area.
So what was it? 2-3 hours?
Yeah, just under 3.
Uh-huh.
Yeah, it wasn't too bad. We didn't really hit any traffic or anything, so
Great.
it was more comfortable in the train. A lot less germs in the train, so more comfortable.
Yeah.
If you need one, we can use it jointly.
You know Josh Cooper with Penn?
That's my electrophysiologist. I love him. He is wonderful. Did he? Did you? Well, thank you too. I absolutely adore him. He is so wonderful. Super nice, super great bedside manner. Very intelligent, very well, like very thoughtful in what he does. Okay.
Yeah, so there's a good connection. Yeah. Yeah. Yeah, I think that is just a timer. And I think the green light is, I think they're probably on. My guess. They're all on.
I'll take up command as soon as go.
Yeah.
I'll take the blame.
I think that that's just a timer. So,
Good morning. Today, it's the afternoon. I'm so out of it. I've been having too many speeches and too many meetings. I apologize. Good afternoon. The subcommittee today is meeting to review H.R. 1346, the Medical Device Safety Act of 2009. We've made huge advances in medicine over the last few decades. New and emerging technologies hold promises that our great-grandparents could never have imagined. Many illnesses that were once a death sentence are now preventable, curable, or at least manageable through modern medical treatments. However, though these medical advancements offer huge benefits, they also present a certain amount of risk. For example, there have been recent stories of patients who have suffered serious injuries from defective FDA-approved devices like implantable cardiac defibrillators and pacemakers. And if I use an example from my home state of New Jersey, there was a young girl, 14 years old, who was one of the victims affected by a faulty medical device. Last year, she felt a very strong pain through her body that she described as a horse trampling me. Eventually, she realized that her implantable cardiac defibrillator was shocking her, and it continued to do so 18 times. When the paramedics arrived at the scene, they found this little girl lying on the floor, begging for someone to remove the device from her body. She spent the next 4 days at a children's hospital waiting to have the surgery to remove the device. Though the faulty device is no longer inside her body, she still suffers from significant anxiety triggered by the slightest heart palpitation or any beeping sound she hears. The medical costs this family in New Jersey now bears as a result of the surgery and side effects are tremendous. Unfortunately, I use that example of the little girl from New Jersey, but the problem is that she and her family have no opportunity for legal recourse, and she's not alone in this problem. In February of last year, the U.S. Supreme Court deliberated the Regal versus Medtronic case and made a decision that, in effect, relieved medical device companies from the responsibility of ensuring the safety of their products. The Supreme Court ruled that patients could not receive compensation for their injuries, medical expenses, and lost wages caused by defective pre-market approval PMA devices or inadequate safety warnings. Now, this decision, in my opinion, ignores congressional intent and is contrary to the medical device amendments, or at least the way they've been interpreted, since the legislation was passed in '76. For the past 30 years, federal regulation through the FDA, together with tort liability, played crucial roles in protecting consumers from risky devices. Already, this Supreme Court decision has had a devastating impact on patients who have been harmed by defective medical devices. For example, a federal judge in Minnesota threw out more than 1,400 lawsuits filed by patients who had defective heart defibrillator wires or leads implanted. Many of them died as a result. And the judge based his decision on the Regal case and noted that the only way to remedy the situation was for Congress to step in. It is crucially important that all the major stakeholders involved in manufacturing medical devices make patient safety their main priority. We must be certain that we're taking every step necessary to ensure that the technologies designed to save lives are not placing people in danger. And much of the data used by the FDA in pre-market approvals for both drugs and devices is limited in the number of individuals who are monitored, as well as in the time frames that they're collected. These studies are vital in making safety and efficacy determinations, while at the same time getting life-saving treatments to patients in a timely fashion. However, the Institute of Medicine has recommended that the risks and benefits of these treatment options should be monitored through the entire life cycle, and this means that the manufacturer has a responsibility for the safety of their product for as long as it's being used by patients, not just during pre-approval trials. Until last year, the state court system provided an additional incentive for companies to actually follow this recommendation. Unfortunately, the Regal versus Medtronic's case and its effects have removed that incentive and provided medical device companies with blanket immunity. The court premised its decision on the theory that FDA approval adequately protects patients from unsafe medical devices, and that theory, in my opinion, has proven false time and again. So that's why I, along with Mr. Waxman, our full committee chairman, introduced the Medical Device Safety Act of 2009, the bill we're examining today. This bill protects patients from dangerous and defective devices by correcting the court's flawed interpretation of the medical device amendments of '76. The bill explicitly clarifies that state product liability lawsuits are preserved and put safety first by eliminating the blanket immunity that medical device companies currently enjoy. There is precedent for this, as the Supreme Court just a few months ago ruled in favor of a plaintiff in a case against a drug company. In that case, the court upheld congressional intent and placed the responsibility for making a safe product squarely within the company's purview. And it's crucial, in my opinion, that we act now to provide patients in need of a medical device with that same certainty. So I want to thank all of you. I'm going to introduce you after we have the opening statements from the rest of the committee. And I now recognize my colleague from Georgia, Mr. Deal.
Thank you, Mr. Chairman. Thank you for having this hearing today, and thanks to the witnesses who come to share their position and opinion on this legislation, H.R. 1346. Although the legislation is less than 1 page in length, the legislative impact of the legislation is significant and I think cannot be discounted based on its own brevity. The United States is and should remain at the forefront of medical device innovation, a position which I believe would be undermined by this bill. The medical industry in the United States has grown as a worldwide leader in innovation and development, providing therapeutic advances for patients and their physicians to treat complicated medical conditions and advance as the advance of science and medicine in our country continues to grow, and this has been shared around the world. Critical life-saving devices such as neurostimulation devices, cardiac defibrillators, and pacemakers have improved the longevity and the quality of life for countless Americans who depend on these technologies every day. What must be considered when evaluating the merit of legislation to eliminate preemption of state tort claims with respect to these critical devices is the resulting impact which will occur on the development of new products. Eliminating preemption will stifle innovation, in my opinion, will increase the risk among manufacturers who are on the cutting edge of medical device development, and prove detrimental to patients in dire need of innovative solutions to complex, hard-to-treat medical conditions. In the case that the chairman referred to of Regal versus Medtronics, the United States Supreme Court, as well as 6 out of 7 federal circuit courts, confirmed the widely held view that the Medical Device Amendments Act, MDA, does indeed preempt state common law claims with respect to devices approved through the pre-market approval process, which is the most rigorous approval process for medical devices. What seems to have been forgotten is that the vast majority of state common law claims involving most medical devices are still permitted. First, the preemption provision provided under the MDA applies to approximately 2% of devices approved by the FDA each year, those which are approved under the pre-market approval pathway. The majority of medical devices each year, those which are approved through the 510K process, are not preempted under current law. Second, it is also important to remember that if a device is improperly manufactured or the source company withholds information from the FDA or misleads the FDA and consumers about the safety and effectiveness of the product, the MDA does not preclude common law tort liability cases in state court. Patients who incur harm are fully capable of pursuing such just recourse for their harm. I urge the members of this subcommittee to take the same approach which the FDA takes in approving these devices by evaluating the risk versus benefits of this legislation. Given the detrimental impact H.R. 1346 will likely pose on development and innovation of promising new technologies promoted by a heightened litigious environment surrounding these products, we will be instituting roadblocks contrary to the overall mission of this committee and of the Food and Drug Administration, which has the responsibility of improving the health of American patients across the country. Thank you, Mr. Chairman. I look forward to the testimony of the witnesses, and I yield back.
Thank you, Mr. Deal. Chairman Waxman.
Thank you very much, Mr. Chairman. I welcome the witnesses to today's hearing as well. Until February of last year, when Americans were injured by defective medical devices, they had a remedy. In most states, they were able to sue the manufacturer of that product for damages in state court. In fact, the only way patients can obtain compensation is to bring a lawsuit under state law. But in February 2008, the Supreme Court dramatically altered this landscape in its Regal versus Medtronic decision. The court ruled that so long as FDA has approved a medical device, patients injured by that device can no longer seek compensation to help them deal with their permanent disabilities, their inability to work, and their costly medical procedures. Ironically, the decision applies only to the most dangerous and most complex devices, the kind of devices that, when they malfunction, often result in death or severe physical impairment. This decision has already had a devastating impact. There are over 1,400 cases brought by injured patients that have been thrown out. We learned that another 300 cases were terminated under Regal. Countless other lawsuits will never be brought. In the wake of the court's decision, it doesn't matter how badly a defective device harmed a patient. It doesn't matter how egregious the device manufacturer's conduct was in marketing a defective device. Patients have no recourse and no ability to be compensated for their injuries. The court's decision was bad for Americans in another way, too. It has destroyed one of the most powerful incentives for safety, the possibility of liability. We know that some device companies have hidden and manipulated important safety data. Some have failed to report serious adverse events. Some have failed to disclose known defects. Yet under the court's decision, even if a company withholds information about potentially fatal defects from physicians, patients, or the FDA, it is still immune from any liability for its actions. In the absence of liability, all the financial incentives will point medical device companies in the wrong direction. Tragically, the end result is that these abusive practices will undoubtedly multiply. Now, some would counter the FDA will be there to protect against these abuses. FDA approved these devices, so why should we have juries second-guessing FDA's expert judgment? Well, as a result of chronic underfunding and weak leadership, FDA's ability to protect the public has plummeted. And in fact, FDA's own science board issued a report saying that the agency is so starved of resources that, quote, American lives are at risk, end quote. But even if we were to give FDA every penny it needs, there would still be a compelling argument for our system of state liability laws. That's because we operate on a model that relies on the industry to innovate, research, develop, and market their medical products. FDA is not the only one playing this role, so the device companies themselves will always know more about their products than the FDA. And here's another problem. The clinical trials upon which FDA relies to approve drugs or devices are often too small to detect less frequent risks. Some risks can only be detected when the drug or medical device is used in the population at large. I was here, as well as Mr. Dingell and very few others on the committee, when the medical device law was adopted. And at no point in the consideration of that legislation did we expect that the preemption language, which was that the FDA has a sole responsibility to approve a product, mean that we were trying to preempt the states from the liability laws. Liability laws have always been in place to serve a very important role, and I was disappointed to see the Supreme Court come up with the decision it did using that language, which of course they did not find in the medical drug section to preempt the state liability laws. I hope that we will overturn the decision of the Supreme Court and allow state laws to continue to play an important role in protecting consumers. Thank you, Mr. Chairman.
Thank you, Chairman Waxman. The gentleman from Illinois, Mr. Shimkus.
Thank you, Mr. Chairman. We're going to hear many difficult and tough stories today, but I know we have Mr. Kinsley here to talk about the other side, and I would just plead for people to remember the thousands of the people who have greatly benefited from, in this case, that one aspect I know is the cerebellar or the spinal cord stimulators. And I had a chance to visit with a couple individuals today, Mike Roman from De Pere, Missouri, and Adam Hammond, who was an Army guy, and I had a chance to visit. And their stories are just as compelling of the serious pain in which they were under, to a point where they were of no benefit only to the pharmaceutical companies, who had to medicate them severely to ease their pain. They were not able to function in today's society, but because of this technological advance, one walked into my office, the other one jumped off the wheelchair, talked to me about how their life had been changed for the good. Now, now the doctors have the Hippocratic Oath, which says, first do no harm. We better be very, very, very careful that in trying to fix the problems of some, we don't turn over the opportunity for this really new life-giving technology to be available for people who desperately need it. So, Chairman, I would preach caution and concern for both sides as we move forward, and I yield back the balance of my time.
Thank you, Mr. Shimkus. Chairman Dingell.
Mr. Chairman, I thank you for holding today's legislative hearing on H.R. 1346, the Medical Device Safety Act of 2009. I am an original co-sponsor of this legislation, and I strongly believe that it is necessary to reinforce congressional intent on a very important policy matter. I want to thank the witnesses who've joined us today and look forward very much to hearing their testimony. Prior to 1976, in the absence of federal regulation, states enacted their own laws governing medical devices. So in an effort to streamline medical device safety policy, the Congress acted. In 1976, we passed the Medical Device Amendments. Our legislative intent was to give the FDA the power to regulate the approval of medical devices for U.S. consumers. We concluded that it was necessary to include a preemptive clause to make sure that federal regulation through FDA preempted state regulation on medical devices. We included no other preemptions. We did not, I note, however, expressly nor implicitly do away with state liability actions. Unfortunately, the U.S. Supreme Court in Regal v. Medtronic, Inc., 2008, decided to create legislative intent where there was none, and immune medical devices from state product liability law. Now, people complain about activist judges. Here's a fine example of people who are running out to find a congressional intent where none existed. I urge my colleagues to remember that there are three coordinate and co-equal branches of the federal government with distinctive duties and responsibilities. The appropriate application of federal preemption should be determined by the Congress, not concocted in preambles to federal regulations or decided through case law. Though in 2008, the Regal decision, an activist judiciary decided to constrict state authority in the way Congress never intended. Therefore, it is time for the Congress to act properly, to exercise our authority to correct this clear judicial overreach. In this instance, the use of tort litigation is beneficial because it will protect consumers where federal regulation fails to anticipate latent danger in medical devices. And when the Congress wants to preempt, I think it has a great talent in saying so in the legislation. None, I repeat, is here to be found. The Food and Drug Administration, I want to note, has been starved for resources for a number of years. This has made it almost impossible for them to adequately ensure the safety of products they regulate. And all you've got to do is look back at the flood of unsafe foods, commodities, pharmaceuticals, and other things coming in from China and elsewhere abroad, as well as things that are slipping into our American economy because of the total inability of Food and Drug to properly protect American consumers. It is to be noted that FDA does not have the ability to ensure the safety of the products they regulate. FDA's IT systems are antiquated. Its science base is eroded. Its laboratories are a joke. And it does not have adequate personnel or, quite honestly, adequate authority to deal with its responsibilities. I will note parenthetically I have a good bill, H.R. 759, that will go a long way in addressing this issue, and we can get back to protecting our people the way we should. And until this can be done, we very frankly need to see to it that citizens and attorneys general have the capacity to properly protect American consumers. So, until we properly equip FDA with the resources to do its job, consumers should have the ability to seek redress under the law. And I would note that of late we have seen many instances where a lot of do-gooders have run out and stripped federal agencies of the authority to regulate, either legislatively or in courts. We saw it in securities, and we saw Enron follow, and a lot of other bad things happened. We saw them do it with regard to banks in the repeal of Glass-Steagall and the deregulation of the securities industry and the deregulation of banks. And all of a sudden we found that we had a magnificent depression on our hands because of abuses of the banks repeated, being the same things that they did in 1920 and 29. Having said this, there may be a day come when we will no longer need state liability to protect consumers from defective medical devices. Unfortunately, that day is not here, and it isn't likely to come until we've dealt with the weakness of Food and Drug, its inadequate budget, and its total inability to properly protect American consumers. For those that paid attention in 1976, we made our intent clear. For those unfortunates needing clarification, we can point to H.R. 1346. It tells people what we had in mind then and what we have in mind now. Thank you, Mr. Chairman, for holding this hearing. I look forward to receiving the testimony of our witnesses.
Thank you, Chairman Dingell. The gentleman from Missouri, Mr. Blunt.
Thank you, Mr. Chairman. Thank you for holding this hearing on the Medical Device Safety Act of 2009. It's certainly important that we carefully consider the possible impacts this legislation could have on patients and the companies that produce life-saving and life-changing devices for those patients. It's extremely important that any medical device on the market undergoes a thorough and appropriate approval process to ensure the safety of the patients who need them. If a company fails to ensure they are manufacturing the highest quality devices and that there are adverse impacts on the patient, then they should be held responsible. On the other hand, if the manufacturer has done everything in its power to put a device through the proper approval processes, correctly manufacture the device, and properly inform its customers, it can't be held responsible for situations beyond its control. We need to make sure, as we look at this bill and this subject, that companies are not subject to overly burdensome regulations because this would ultimately cause patients to suffer in the form of decreased access and decreased innovation of medical devices. I look forward to working with you, Mr. Chairman, with Mr. Deal and the subcommittee as we move forward on this issue. I also look forward to the panel today.
Thank you, Mr. Blunt. Mr. Murphy of Connecticut.
Thank you very much, Mr. Chairman. Just very briefly, I'd like to thank you for holding this hearing today. And I understand that the focus of much of our discussion today is going to be the precedent set in Regal. But as someone new to this debate, I look forward to hearing from the panel about their ideas on how to truly make the fundamental reforms to the FDA process that Mr. Dingell and many others have referenced. I absolutely believe that tort law can be an effective check against unsafe products, but I also understand that it can be a patchwork check on those products. And so I look forward to hearing today both about the precedent that has been set and our opportunity to transform it. But I also look forward to hearing from this panel and those who will come before this committee in the future to hear about how we can truly put teeth into the FDA. There's no reason to give up on that process, and I stand ready at the very least to be part of a process by which we can make that approval process work once again. Thank you, Mr. Chairman.
Thank you. Gentleman from Indiana, Mr. Boyer.
Thank you, Mr. Chairman. I want to comment on 2 points. One came from my dear friend, Mr. Waxman. The reason I need to make this point is that he talked about how the FDA right now, being an underfunded agency, is ill-equipped to protect the public because it has been woefully underfunded. All right, let's stop and think about that for a moment. Woefully underfunded. Mr. Waxman, what did you just do and this committee just do with regard to tobacco legislation? You gave it a new mission on top of a core mission that is counter to its culture. And if, in fact, we have an agency that's underfunded, we should be funding the agency and making sure that it does its job, and so that the best minds in the world can assess these products to make sure that we have the gold standard of safety. Not to say, let's turn it over to juries and judges and the cleverness of trial lawyers. That is the wrong place. That is the wrong venue. It is the wrong jurisdiction to have the supervision of medical devices. So that is a bizarre logic for me. Second point, with regard to my other dear friend, Mr. Dingle, talking about activist judges. Boy, this is in the hands of the beholder when conservative courts are now considered activist courts because of its interpretation of the law. And now, whom are they embracing? No, who they're embracing is the circuit, the 11th Circuit, that is out of step with all other circuits, is who Mr. Waxman is embracing. For the years that I served on the Judiciary Committee, I sought to sever the 11th Circuit. I'd break it into 6 parts if I could. It is the most bizarre circuit with regard to its judgments for the country. So for us as a committee to embrace the 11th Circuit as though that is, in fact, the judgment that should be made for the whole of the country, I think is twisted logic. Now, I agree with the judgments of the Supreme Court. I think they made the right decision. I think they brought clarity to the issue. And the other point I want to make is that in the court's decision in Regal, it confirmed, yes, that the MDA does preempt state common law with respect to devices approved through the pre-market approval process. But it further confirmed that the manufacturer, if it engages in wrongful conduct, the manufacturer can be held liable. Now think about if some of us, if we wanted to go to the marketplace at risk, pool our capital, push the bounds of science, and we've created something, we go through the approval process, we do everything that the FDA says we're supposed to do. Yet what? We want to turn that over, even though I've done everything we're supposed to do, to all these state court jurisdictions? If I'm the manufacturer and I've got a state out there that is out of step and bizarre, I will not market that product in that state. And then the people who live in that state then will suffer. Is that the type of equity we bring to America? I don't think so. I yield back.
Mr. Braley of Iowa.
Thank you, Mr. Chairman, for holding this important hearing. It's a very important distinction to draw that what we're talking about today is a restoration of rights that existed in this country for over 100 years, not the creation of some new cause of action. In fact, Justice Ginsburg, in his dissenting opinion, referred to this as a radical curtailment of state common law remedies. And as someone who has not only researched, briefed, and argued federal preemption cases in both state and federal courts, I can tell you from personal experience that the key issue in every federal preemption case is the original intent of Congress as expressly stated, and that in the application of the law to that issue, the question is always a presumption against preemption because it is such an extraordinary action to take. And in fact, the court, in its opinion, cited the legislative history, which is always one of the first things you look at in determining congressional intent. And it referred specifically to the Senate sponsor of the bill, Senator Kennedy, who noted at the time the bill was introduced, the legislation is written so that the benefit of the doubt is always given to the consumer. After all, it is the consumer who pays with his health and his life for medical device malfunctions. And it also quoted Chairman Waxman, who I'm sure would be surprised that he was being cited as one of the contributing members whose congressional intent shaped the court's eventual outcome. One of the things that was also mentioned in the dissenting opinion was the perverse effect of immunity. And the court focused on the fact that at the time this act was brought before Congress in 1976, it was at a time when the entire industry, according to the judgment of Congress, needed more stringent regulation. And if you look at Justice Scalia's opinion, he notes that when these devices enter the market, they have never been formally reviewed under the MDA for safety or efficacy. And Mr. Chairman, I'd like to note, as Chairman Waxman referred to earlier, that just today in the United States District Court for the District of Minnesota, 300 additional people who were injured or killed by defective medical devices had their cases thrown out because of this decision. And I would ask unanimous consent for the ruling that was handed down today to be included as part of the record.
Without objection, so ordered.
Now, one of the things we often hear about is reasons that this bill should not be passed. Let me give you 4 conservative reasons to support the passage of this bill. Number 1, it holds corporate wrongdoers accountable when they injure or kill people with defective devices. Number 2, it does, when you provide immunity to medical device manufacturers, you create greater exposure for the physicians who install them and the hospitals where they're installed. Number 3, as Dr. Mizell noted last year during our hearing, it results in cost shifting to U.S. taxpayers who end up paying for the care of these patients who have no other remedy. And 4th, we see a flood of defective medical devices flowing in from overseas. That's a conservative reason right there, and that's why we need to pass this bill.
Thank you. Gentleman from Pennsylvania, Mr. Pitts.
Thank you, Mr. Chairman. Thank you for convening this hearing. The bill we're discussing today, H.R. 1346, would overturn the 8-1 Supreme Court decision in Regal versus Medtronic. In this 2008 decision, the court held that the preemption clause contained in the Medical Device Amendments Act bars common law claims challenging the safety of a medical device granted pre-market approval by FDA. This decision is extremely limited in scope. Only those devices that receive pre-market approval, or PMA, approximately 2% of the new medical devices marketed per year have express preemption. Regal also makes it clear that preemption does not apply to PMA devices if the manufacturer withholds information from the FDA, misleads FDA about the safety or effectiveness of its product, or the company manufactures a product improperly. In such a case, the company can be sued for its wrongful behavior. The PMA process is scientifically rigorous. The FDA spends an average of 1,200 hours reviewing each application, including the device's proposed labeling. And in granting PMA, the FDA has determined that the probable benefit to health from the use of the device outweighs any probable risk of injury or illness from use. Once a device is approved through the PMA process, the manufacturer is subject to reporting requirements, including informing FDA of new clinical or scientific studies regarding the device and reporting incidents in which the device failed or contributed to significant injury. FDA can withdraw approval if a device is found not to be safe or effective. FDA can order a recall if it is determined that a reasonable probability exists that a device could cause serious injury or death. What would the consequences be if these life-saving complex devices did not receive express preemption, as would be the case if H.R. 1346 became law? Companies that manufactured and labeled their products according to FDA-approved standards could be sued in state courts and found at fault if a device causes injury or harm. A lay jury would be presented with a case in which an individual was harmed by a device, and its judgment would be substituted for that of the FDA. 50 courts in 50 states could each determine what standard a device should meet. Innovation would be stifled. Venture capital could dry up with the threat of litigation once a product hits the market. Manufacturers could pull products from the market or refuse to sell them in certain states as a result of court cases. People who desperately need these life-sustaining devices may not have access to them. No device, no matter what the approval process, will ever be 100% safe and effective. But when FDA grants pre-market approval, it has judged that the benefits to the population at large outweigh the risk to the population at large. The Regal case was decided properly, and H.R. 1346 is simply bad policy. We all want only those medical devices that are safe and effective to be on the market. H.R. 1346 will not help us to achieve that. I look forward to hearing the witnesses today, and I yield back.
Thank you, Mr. Pitts. The gentleman from Texas, Mr. Burgess.
I thank the chairman, and I thank the witnesses for being here with us today and listening to our opening statements. We'll listen to yours in just a moment. Certainly, the Food and Drug Administration categorizes devices into three categories. Class 1 devices are subject to minimal requirements. Some easy examples of that would be latex gloves and bedpans and urinals. Class 2 devices are subject to more requirements and include such items as hearing aids. But H.R. 1346 is not aimed at Class 1 and Class 2 devices. It is aimed at high-risk devices known as Class 3. Class 3 devices are considered high risk because they are complex and used to support or sustain human life, or whose use is of substantial importance in preventing impairment of human health. They are most certainly life-changing devices with no 100% guarantee of safety or efficacy. With Class 3 devices, there are calculated risks involved. Now, weighing the risks, the interests of a manufacturer against the life of a human being, no question about what side you come down on. Come down on the side of the human being. But preemption does not do that, nor does preemption bar state common tort laws. Preemption is not a get-out-of-jail-free card for bad actors taken to court. If a medical device manufacturer violated the essential premise of producing a safe product, there are still remedies, despite the Supreme Court's 8-1 ruling in Regal versus Medtronic. But what the Supreme Court recognized in Regal versus Medtronic is two things. First, the Supreme Court found that pre-market approval for devices by the Food and Drug Administration is rigorous, even arduous. 1,200 hours or more of review for each potential device. You have to undergo clinical trials, and a company must give countless pages of documentation to the scientific experts at the Food and Drug Administration. And review by the Food and Drug Administration does not end with pre-market studies. Post-market approval is continuous and frequent. If a manufacturer fails to maintain the Food and Drug Administration's standard of approval by being disingenuous or a failure to be transparent, then approval can be rescinded. The strenuous nature of pre-market approval process is evident in the exponential rise in the 510K applications, where a device is allowed to go to market if there are what are known as substantially equivalent devices. Now, Mr. Chairman, I've requested a hearing on the 510K process in March of this year. I am concerned about how devices are being approved at the FDA. If the FDA is broken, if the FDA is under-resourced, as Chairman Waxman suggested, if the FDA is understaffed and underwater, if the FDA is ill-equipped, inadequate, or severely underachieving in its Class 3 medical device process, then let's do what's within our power and fix the FDA. This subcommittee is not tasked with fixing the legal system. H.R. 1346 is tort reform, but it's tort reform at its very worst, utilizing the worst possible mechanism. H.R. 1346 would create a haphazard system, a virtual patchwork of device standards, where lay jurors are elevated to the same standard of expertise, knowledge, and grasp of science as someone on an FDA advisory panel. Furthermore, an attorney general in California, or an ambitious attorney general in New York, or an even-keeled attorney general in Alabama could each create their own sensational trial with sensational damage figures regardless of what the Food and Drug Administration does. If there ever was congressional intent in the enactment of the Medical Device Act of 1976, it would be this: federal ceilings to tort liability as it relates to medical devices must exist as a necessity to encourage innovation and a healthy progress in medicine. Without a ceiling, no doctor will ever use a medical device and risk his or her entire professional future to a jury. and no manufacturer will ever undertake the risk of producing a single device where a single error will result in the destruction of the entire livelihood of that company. The science of devices should not be in the judicial branch. The judicial branch should determine the law, and the law here is written by Congress. So the solution regarding medical devices is to give the Food and Drug Administration the resources that they need to do the job that they have been tasked to do, and not to enact H.R. 1346. I thank you, and I'll yield back the balance of my time.
Thank you. Our ranking member, the gentleman from Texas, Mr. Barton.
Thank you, Mr. Chairman. I'm going to submit my full statement for the record. But I do want to read one paragraph from the Republican Staff Committee brief for this hearing about H.R. 1346. And before I do that, let me say I do appreciate that we're having a legislative hearing. I wish it were on another bill, but at least we're having a hearing. But let me just put it in a nutshell what my position is and what I think most of the Republicans on the subcommittee's position is. Enacting H.R. 1346 will not only overturn the Supreme Court's 8-1 decision in Regal versus Medtronic, it will also severely disrupt the innovation in the medical device industry that has existed since the enactment of the Medical Device Amendments Act of 1976 to the Federal Food, Drug, and Cosmetic Act. This disruption will decrease patient access to life-saving medical devices, threaten the U.S.'s status as a global leader in medical device innovation, and dramatically increase the number of lawsuits against device companies. So, Mr. Chairman, again, thank you for holding the legislative hearing, and we will certainly listen to our witnesses, but I would hope that you have no intention of moving this bill. There are more important bipartisan issues that we can work on together for the good of the country. This is not one of them. With that, I yield back.
Thank you, Mr. Barton. Next is the gentlewoman from Tennessee, Ms. Blackburn.
Thank you, Mr. Chairman, and I thank our witnesses for their patience today. And we've had a lot of conversation so far about the bill that you're going to testify on. I think it's important to make just a couple of notes as we move forward to your testimony, and I will submit my full statement, Mr. Chairman. It was, as Chairman Dingell said, over 30 years that Congress enacted the medical device amendments. They were there to create a uniform national process for evaluating the medical devices. They have done that. Subsequently, the FDA successfully implemented the pre-market approval process, which gives the specific guidance to the medical technology companies that they follow to ensure the safety of those devices. They spend an average of 1,200 hours reviewing every single application. That is a lot of time on every one of those applications. Now, common sense would dictate that the FDA and the medical technology companies are committed to making available the safest devices possible to save lives. Anyone who believes that these companies are out to purposefully make poor performing products ought to return to Business 101 and realize that companies know if you put bad products into the marketplace, it will eventually lead to a company's collapse. So in order to stay competitive, medical technology companies like Medtronic, Smith & Nephew, and Wright Technologies, which are all in my district, continue to develop and produce innovative technologies in order to save lives. Also, I'm troubled that some in Congress would weaken the current device review system in the name of consumer safety. I do think the act is misnamed. It would be a boon for trial lawyers at the expense of public safety. I think the other provision we have to look at is the device sector is responsible for almost 2 million jobs. Thousands of jobs in my district alone. I have personally toured many of the facilities and am continually impressed by the innovation, the research, and the commitment to saving and bettering lives that I have found at each one of the facilities. Thank you, Mr. Chairman. I yield back.
Thank you. Gentleman from Georgia, Mr. Gingrich.
Thank you, Mr. Chairman. Today, as a result of advances in medical technology, Americans enjoy access to a quality of health care that most nations do not. While some countries restrict or ration the types or the amounts of drugs and devices that patients can access, American patients can receive the latest, the most advanced medical technology, such as an artificial hip or the latest cancer medication that will drastically improve and extend their lives. Mr. Chairman, ensuring the safety of medical devices is an absolute necessity for our continued access to quality health care. The FDA is charged with making certain that all medical devices have been thoroughly tested for safety and effectiveness before coming to the market. It is one of the FDA's primary responsibilities, and I support increased efforts in this area. Unfortunately, modern medical procedures inherently have risk associated with them, regardless of advances in technology or effective oversight. It goes without saying there are very few absolutes in this world. With this thought in mind, I look forward to the testimony of our witness today. I yield back, and hopefully we'll use some of this additional time for questioning. Thank you, Mr. Chairman.
Thank you, Mr. Gingrey. That's the end of our opening statements, so we're now going to turn to our witnesses. We have just one panel, and I want to welcome you all for being here today. Let me introduce each of you from my left to right. First is Professor David Vladeck, who is a professor of law at Georgetown University Law Center here in D.C. Next is Dr. William Maisel, who is director of the Medical Device Safety Institute for the Department of Medicine at Beth Israel Deaconess Medical Center in Boston. And then we have Dr. Gregory Kerfman, who is editor of the New England Journal of Medicine, and Bridget Robb, who is, I know that's that Welsh name, I always get it wrong, Gwynedd, Pennsylvania. And then is Mr. Richard Cooper, who is a partner in Williams & Connolly. And finally is Michael Kinsley from Seattle, Washington. Thank you all for being here today. Now, the way we work it, we have 5-minute opening statements. They become part of the hearing record. You may, in the discretion of the committee, submit additional statements in writing for inclusion in the record, after your testimony. And I'm going to start on my left again with Professor Vladeck.
Mr. Chairman, is this on? Mr. Chairman and members of the committee, thank you very much for inviting me to be here today. The bill, H.R. 1346, proposes to restore to consumers injured as a result of defects in life-supporting and life-sustaining medical devices the right to sue medical device manufacturers. My views are these. The Supreme Court ruled...
Professor, just move the mic a little closer, and I'm going to ask everybody to do the same. It'll be easier to hear you.
I think it's on.
It's on, but it's better to speak a little closer to it.
All right. My views are these. Regal versus Medtronic provides very broad immunity from tort liability to manufacturers of medical devices, and the ruling gives consumers the worst of both worlds. On one hand, the FDA cannot single-handedly assure the safety of the thousands of medical devices on the market today. Too many serious defects have emerged with FDA-approved devices, and too many patients have been killed or injured by defective devices to contend otherwise. On the other hand, in the aftermath of Regal, patients injured by devices are left with no remedy at all. No compensation for the pain and suffering they endure, no reimbursements for the costs of surgery and medical care, and no recompense to their loved ones should they die. Making matters worse, manufacturers have little economic incentive to swiftly recall devices or to repair defective devices on their market, since they are immunized from liability and tort. I recognize that Regal ruled that Congress, in passing the medical device amendments, conferred immunity from tort liability to device manufacturers. In my view, Regal is wrong as a matter of history, as a matter of law, and a matter of policy, and Congress ought to swiftly overrule it. First, Regal's wrong as a matter of history. As Chairman Waxman, Mr. Dingell confirmed, the members of Congress who enacted the medical device amendments know that Congress never intended the medical device amendments' very narrow preemption provision to restrict the rights of injured parties to sue for compensation. Cutting off tort liability was not Congress's goal in that statute. Second, it's wrong as a matter of law. The medical device amendments were passed to strengthen consumer protection. The statute was passed in the wake of the notorious failure of the Dulcan Shield, an intrauterine device that harmed and killed many women. The legislation was intended to strengthen consumer remedies, and it is odd in the extreme to say that Congress intended to insulate manufacturers from the tort liability that was instrumental in bringing justice to people injured by defective medical devices. The last point, and the most important point, is that Regal is wrong as a matter of policy. Immunizing device manufacturers, and device manufacturers alone in terms of manufacture of medical products, harms the public in several ways. First, immunity removes incentive to manufacturers to fix devices quickly and get defective devices off the market. Time and again, we've seen device manufacturers find defects in their devices, make important safety improvements, yet continue to sell their older, riskier devices until they sell out their inventory. Tort law would constrain that practice. Second, immunity weakens the incentives to disclose defects to physicians and patients without delay. Again, time and again, we've seen device manufacturers fail to do that. Again, tort liability would constrain that practice. Third, immunity eliminates the compensatory justice role served by the civil liability system. It shifts all of the costs of injuries and deaths from the manufacturers onto consumers who can ill afford it, to insurance companies, and ultimately to taxpayers. What we've done is simply shift the burden of risk off the manufacturer onto the shoulders of the taxpayers. The arguments that defend Regal are off target, and history proves this point. Life-saving and life-sustaining medical devices have been marketed for decades. For all but a very brief period, there's been no preemption. Preemption is a fleeting phenomenon. It has not been the norm with respect to medical devices. Yet, for virtually all of the time, FDA regulation and state tort litigation have coexisted, each placing an important but complementary discipline on the marketplace, without impairing the FDA's function and without any of the harms the defenders of Regal fear. For instance, the United States industry for medical devices remains and has always been the most innovative in the world. The American manufacturers of medical devices dominate the international market, even though there's long been a backstop of tort liability. I see my time is up. Let me just make one last point. The Supreme Court in Regal said that preemption was decreed by Congress. Congress has the power to fix it. I urge that Congress restore consumers to the place they were prior to Regal without delay. Thank you very much.
Thank you, Professor. Dr. Maisel.
Thank you, Chairman Pallone, distinguished members of the committee. Thank you for the opportunity today to speak about the importance of the Medical Device Safety Act of 2009. My name is Dr. William Maisel. I am a practicing cardiologist at Beth Israel Deaconess Medical Center and assistant professor of medicine at Harvard Medical School in Boston. And I'm also director of the Medical Device Safety Institute, an industry-independent nonprofit organization dedicated to improving the safety of medical devices. I have served as a consultant to the FDA's Center for Devices and Radiological Health since 2003, and I have previously chaired the FDA's post-market and heart device advisory panels. I hope that by the conclusion of my brief remarks today, you will appreciate that FDA marketing approval of a medical device does not guarantee its safety. In particular, manufacturers' responsibilities for product safety extend well beyond initial FDA approval, and it is apparent that additional consumer safeguards are needed if we are to improve the safety of medical devices for the millions of patients who enjoy their benefits. We are fortunate to have the preeminent medical regulatory system in the world. The U.S. Food and Drug Administration regulates more than 100,000 different medical devices manufactured by more than 15,000 companies. They receive several thousand new and supplemental device applications annually, and they are mandated by Congress to complete their pre-market evaluations in a timely fashion. Mark Gleason is a man whose very life depends on one of these implantable medical devices, in his case a pacemaker. Pacemakers are implanted to treat dangerous slow heart rhythms, And in Mr. Gleason's case, every single beat of his heart comes from his device. The pacemaker itself consists of a battery and computer circuitry sealed together in a metal housing. Although pacemaker batteries typically last 5 to 10 years, Mr. Gleason required surgical replacement of his pacemaker after just 12 months due to a short circuit that caused the battery to wear out prematurely. St. Jude Medical, the manufacturer of Mr. Gleason's pacemaker, had become aware of the short circuit problem 2 years earlier because other faulty devices had been returned to the manufacturer. St. Jude asked for and received FDA approval for a modified version of the device that corrected the problem, although they continued to distribute already manufactured, potentially faulty pacemakers with the FDA's knowledge, but without public disclosure. When Mr. Gleason needed his faulty pacemaker replaced, he received another potentially faulty device, even though corrected pacemakers had been built and were available. Ultimately, St. Jude Medical issued a recall of 163,000 pacemakers, including Mark Gleason's new unit, but not until nearly 2.5 years after initially learning of the problem. As Mr. Gleason wrote to me, it is unacceptable that St. Jude Medical was permitted to continue to sell known defective inventory of a device with impunity. One possible conclusion is that St. Jude Medical weighed the likelihood of death or serious injury against the cost of pulling defective inventory off the market. While Mr. Gleason's case occurred several years ago, it is not an isolated event. Other manufacturers have also knowingly sold potentially defective devices without public disclosure. The FDA annually receives reports of more than 200,000 device-related injuries and malfunctions and more than 2,000 device-related deaths, and it is challenging for them to identify patterns of malfunction among the deluge of adverse event reports. In the majority of cases, FDA relies on industry to identify, correct, and report the problems, but there is obviously an inherent financial conflict of interest for the manufacturer that's sometimes measured in billions of dollars. The U.S. Supreme Court, with their February 2008 decision, Regal v. Medtronic, removed an essential consumer safeguard, the threat of manufacturer liability. Implanted medical devices have enriched and extended the lives of countless people, but device malfunctions and software glitches have become modern diseases that will continue to occur. The failure of manufacturers to provide the public with timely, critical information about device performance and malfunctions enables potentially defective devices to reach unwary consumers. Patients like Mark Gleason are sometimes forced to make life-changing decisions with insufficient and sometimes inaccurate information. We have consumer protections for airline passengers, for cable television customers, and for cellular telephone users, but surprisingly few for patients who receive life-sustaining medical devices. The Medical Device Safety Act of 2009 provides important and necessary consumer safeguards that will minimize adverse health consequences and improve the safety of medical devices for the millions of patients who enjoy their benefits. Thank you.
Thank you. Dr. Kerfman.
Thank you, Chairman Pallone and other distinguished members of the subcommittee. I want to thank you for inviting me to participate in this important hearing. My name is Gregory Kerfman. I'm the executive editor of the New England Journal of Medicine. I will argue that preemption of common law tort actions against medical device companies is ill-advised. Preemption puts the interest of corporations before the interest of patients. It denies patients their rights and will result in less safe medical devices for the American people. For nearly 200 years, the New England Journal of Medicine has been publishing articles on innovative drugs and medical devices. We strongly support medical innovation. We are a medical journal. But we are a patient-focused medical journal, and we are committed to patient safety. Now, Mr. Chairman, innovation and safety are not mutually exclusive. We can and we must have both. Patient safety is a national concern. Major stakeholders throughout our healthcare system agree that every step must be taken to ensure that medical interventions are as safe as possible. Unfortunately, one major stakeholder, the medical device industry, has been shielded from the potential consequences of failing to adequately disclose risks. This was the result of the U.S. Supreme Court decision in Regal v. Medtronic. Until that ruling, the possibility of litigation for failure to warn or design defect served as a strong incentive for device companies to be vigilant about the safety of their products. Medical devices are often approved on the basis of only small, short-term clinical trials, and a number of devices have been approved through a fast-track process that does not require any clinical testing at all. The approval process leaves patients vulnerable to safety problems that have gone unrecognized during the pre-marketing period, only to emerge during the post-marketing period. Since the Regal ruling, as Chairman Waxman mentioned, thousands of lawsuits against medical device manufacturers have been tossed out of court by judges following the Supreme Court's lead. Now, litigation, or the threat of litigation, has been effective in removing potentially harmful medical products from the market. And there are a number of examples. They include the diet pill dexbenfluramine, or Redux, the COX-2 inhibitor rofecoxib, or Vioxx, and the cholesterol-lowering drug cerevastatin, or Baycol. But the examples are not limited to drugs. A number of medical devices have been removed from the market after injuries and litigation. Among them, the Dalcon Shield that Professor Vladeck mentioned, the Bjork-Shiley heart valve, and recently the Sprint Fidelis cardioverter defibrillator lead that we will hear more about. Mr. Chairman, let me be clear. I am not here to promote lawsuits. I am here to promote the interest of patients. I oppose preemption because it removes a legal mechanism by which patients who have been harmed can be compensated, and because it will inevitably result in less safe medical devices for the American people. The way to prevent lawsuits is to put safe medical products on the market. The Supreme Court's ruling in Regal was based not on considerations of what is best for the health of the public, but rather on a point of statutory law. In marked contrast to Regal, the Supreme Court ruling last March in the drug preemption case, Wyeth v. Levine, dismissed Wyeth's argument that failure to warn suits against drug companies are preempted by FDA approval of the drug's label. Now, as the law stands, failure to warn and design defect lawsuits are preempted for medical devices, but not for drugs. This perplexing state of affairs defies all logic. The Medical Device Safety Act of 2009 addresses this legal inconsistency. The bill would nullify the court's ruling in Regal and would thereby place medical devices and drugs on a level playing field with respect to patients' rights. I urge you and your colleagues in Congress to swiftly pass this legislation. The critical issue of preemption should be decided by officials elected by the people. Mr. Chairman, I hope that this testimony is informative, and I look forward to answering any questions that you may have.
Thank you, Doctor. Ms. Robb?
Chairman Pallone and members of the Health Subcommittee, thank you for inviting me to speak to you about my personal experiences with a faulty medical device and my reasons for supporting the Medical Device Safety Act, H.R. 1346. My name is Bridget Robb, and I'm a 35-year-old mother and resident of Gwynedd, Pennsylvania. On December 31st, 2007, I suffered greatly and thought I was going to die because of a defective heart device implanted in my body. I'm thankful to be here today, and I am pleased that Chairman Pallone has reintroduced the Medical Device Safety Act, which would restore the right of patients like me to hold manufacturers accountable when their products cause injury and sometimes even death. Approximately 5 years ago, I was diagnosed with non-ischemic viral cardiomyopathy and congestive heart failure. In May of 2005, to prevent me from dying from a fatal arrhythmia, I had a Medtronic cardiac defibrillator implanted in my chest.
This heart device is a small metal case that contains electronics and a battery. Its components work much like a pacemaker, but unlike a pacemaker, an ICD delivers an electrical shock to the heart when the heart rate becomes dangerously fast. On December 31st, 2007, I was awoken from my sleep by a series of shocks to my heart, which felt as if a cannon was being repeatedly shot at my chest at close range. Along with these recurrent shocks was a strong electrical current racing through my body. After feeling the first shock, I immediately phoned 911 for help. My then 6-year-old daughter, Emma, had snuck into bed with me that night and was present during this horrific experience. I remember Emma being scared and confused. She crouched down in front of me, hugging our cat, saying, "Mommy's dying." She was present during the entire 7 minutes that I was on the telephone with the 911 operator until the EMS arrived. I cannot imagine how terrified she must have been to see her mother in such pain. My doctors have told me that I received a total of 31 dangerous shocks to my heart in a matter of minutes that morning. Each time I was shocked, I saw my life flash before my eyes. It was excruciating pain. At one point, I began to pass out and thought that I would never see Emma again. Every day since then, I've been unable to sleep. Ever since that day, I've been unable to sleep in my own bed due to the trauma that I have experienced. I later learned that the agonizing shocks and electricity coursing through my body was caused by a defective cardiac lead implanted in my heart, the Sprint Fidelis lead, manufactured by Medtronic. A lead is a thin wire that connects the ICD to the heart and delivers the actual shock to the heart when it is beating too fast. Medtronic's Sprint Fidelis lead was recalled on October 15, 2007, because of its potential to fracture. Despite receiving over 1,000 complaints about the defective lead, it took Medtronic 3 years to issue this recall. Since this terrifying experience, my health has declined significantly. I visit doctors weekly because of my ongoing health issues due to this event. After the inappropriate shocking from my lead, I underwent surgical replacement of my defibrillator and defective lead, and a second surgery to adjust the new lead. My second surgery resulted in an extended hospital stay where I had to undergo a blood transfusion. Most recently, in September 2008, my incision ulcerated and became extremely painful. I was hospitalized a series of times, once for 2 weeks straight, in an effort to cure this problem. To prevent an infection to the hardware in my chest, my doctors ultimately decided to remove my defibrillator altogether. Right now, my doctors continue to try and stabilize my decreased heart function, and I take various medications that carry serious health risks, which I never took before. As you would expect, I risk serious harm each time another procedure is performed. From the time between my diagnosis in 2004 and the horrifying shocking in December of 2007, I was never hospitalized for my heart failure except to have my defibrillator implanted. My heart function had significantly increased due to my medications, and I had a good outlook from my doctors. However, since my defective lead misfired, I've been hospitalized at least 8 times, mostly for 1 to 2 weeks at a time, and my heart function is much lower than it used to be. I'm a single mother, so as you can imagine, this has been trying for both my daughter Emma and myself. Each time I'm hospitalized, it becomes more difficult on my daughter, since she is afraid that one of these times I won't come home. Even though Medtronic's defective device caused my injuries, my health insurance plan has been paying for the cost of my medical care. It is wrong to shift the cost of medical care from the responsible party to private insurers, patients, and in some cases to taxpayer-sponsored programs like Medicare and Medicaid. I would like to have the opportunity to hold Medtronic accountable for the injuries that I suffered that day and the physical and emotional after effects that I continue to experience on a daily basis. I find it discouraging and demoralizing that I have no recourse for my injuries, and that a company that manufactured a defective product that has harmed me and thousands of other individuals has no accountability. I encourage Congress to act quickly and pass the Medical Device Safety Act. It is extremely important that injured patients have a remedy for their injuries and that the cost of their medical expenses and other needs are not borne by Medicare, private insurance, employees, and patients themselves. The medical device industry should be accountable for their products, just like the drug companies or any other industry. Thank you for your commitment to this critical issue. I am happy to answer any questions that you may have.
Thank you, Ms. Robb. Thanks so much for being here.
Thank you.
Mr. Cooper,
Thank you, Mr. Chairman, members of the subcommittee.
you have to get that mic closer to you. And
Thank you, Mr. Chairman, members of the subcommittee for inviting.
is it on?
Yes, green light.
Oh, right, maybe just
Out.
a little closer. It'll be,
For inviting me to testify here today. I am here on my own, not representing any organization.
I don't know if it's working, Mr. Cooper. I'll try that.
I'll try this one.
That's
Yeah.
much better.
I'd like to make 3 points. The first is a number of the opening statements referred to what the members called defective devices. The fundamental issue here is who ultimately decides whether a device is defective. Is it the physicians, the engineers, the materials scientists, the chemists, the statisticians, and other experts at FDA? Or is it juries and judges in the 50 states and other jurisdictions that will hear products liability cases? By what process should that decision be made? By people who review enormous volumes of data, who over time, even after approval, receive reports from manufacturers of malfunctions or injuries, who can commission special studies, who can send inspectors into manufacturing plants to review all of the manufacturing records and interview the employees who design and manufacture the products? Or should it be people who listen to a couple of lawyers rant at them and observe witnesses being examined and cross-examined? And what perspective should guide that decision-making? The perspective of people who look at all those who will use a device, those who will benefit from it, as well as those who will suffer from malfunctions, or a group that spends day after day in court observing an injured plaintiff. I submit to you that the ultimate decision should be made by the Food and Drug Administration, which, if properly funded and subject to proper oversight, is a national treasure. Second, products liability law is not insurance. It's about fault. And a manufacturer that puts on the market a product with a design approved by the Food and Drug Administration, with the perspective I've described, by the experts I've described, and with the procedure I've described, is not at fault for marketing a device with that design, and similarly for other aspects of a device that FDA approves. Third, the concern about the effect of products liability litigation on incentives for innovation is not mere theory. It's real. A number of years ago, I served on a committee of the Institute of Medicine that issued a report. The report came out in 1990, called Developing New Contraceptives, Obstacles and Opportunities. And one of the principal obstacles to innovation in that medical field that the committee, which included primarily physicians, that the committee identified was products liability. It summarized its conclusion from its analysis as follows. I quote from its report: "Without changes in the products liability rules and procedures, it appears likely that even fewer firms will allocate even fewer resources to contraceptive research and development." Close quote. That's just one small medical field, and indeed a field that probably doesn't involve devices to which preemption under Regal would apply. But the effects of products liability risks are great. Most medical device companies are small. To develop a product in a field that has great risks of litigation is to bet the company on every product, and that isn't prudent when there are other things that can be done. And since 1990, and this report was issued, there hasn't been a lot of innovation in contraception. And there are other medical fields which are underserved due to liability risks. So that is something I would suggest you consider. This isn't corporations versus people. This is how best to serve people, how best to serve patients who need medical devices, whose lives are supported or sustained by medical devices, and whose adverse health conditions can be greatly alleviated by them if companies have the incentive to develop them and they're presented to FDA for its review. Thank you.
Thank you, Mr. Cooper. Mr. Kinsley?
Does this work? No. All right.
Here, why don't I switch seats with you for the moment?
Okay.
Good idea to switch seats.
Thanks for this opportunity to testify, Mr. Chairman. I'm here because I was approached last week by Medtronics, but I'm here representing myself. I'm not accepting anything from them except for Xeroxing of copies of my testimony. I also have I'm not an expert on federal preemption issues, and I don't even have a view about the question of whether standards should be similar between drugs and devices. I also have no view about the goings-on in the 11th Circuit, although it sounds pretty exciting. I'm here for two reasons. First, as a grateful customer of the pharmaceutical and medical device industries. I have Parkinson's, and I've had it for over 15 years. As I hope you can see for yourselves, my symptoms are pretty mild after all that time. They have not affected my ability to work, to travel, or to enjoy life. This is true thanks in part to drugs, including many that have just come on the market in the years since I was diagnosed. And it is true especially because of surgery I had 3 years ago called deep brain stimulation. Now I walk around with wires in my head and 2 pacemaker-type batteries in my chest. But thanks to these devices and these pills, I am walking around, which is encouraging to me. I'm also here as a journalist who's written quite a bit about the damage done to our economy and to our country by excessive litigation in general and product and medical liability lawsuits in particular. And with all due respect to Dr. Kerfman, if he thinks that companies can avoid litigation simply by producing safe products, I think he's naive. We all want the government to protect us from dangerous drugs and devices, but we don't want the government to prevent us from getting helpful or life-saving drugs and devices. And the central problem is that those are the same devices, the ones that threaten us with harm sometimes and the ones that help us most of the time. And you do not want a system, even if you could have it, that only allowed safe devices to be produced, because that would be too far over on the scale. You need to have, in order to maximize the benefit, you have to tolerate some risk. And the danger of using litigation to solve these problems is that it forces us as a society to be overcautious. I think I'll even stop there.
Thank you, Mr. Kinsley. Thank you all. We're going to proceed to questions now from the members of the committee, and I'll start with my own questions, and I guess I'll start with Professor Vladeck, if I may. Many people looked at the fact that the Regal decision was decided with an 8-to-1 vote by the Supreme Court in favor of preemption as evidence that it's clear that all FDA product liability cases should be preempted. I wanted to ask you, how could the court be wrong about that when it was such an overwhelming margin? Can you explain why the Regal decision was 8-to-1?
I can take the court at its word. What the court said was, and this goes back to an earlier decision by the court in the case involving cigarette labeling chip alone, many statutes that have preemption provisions use the same language. And the language is requirements different from or in addition to those prescribed by federal law. And the battleground since 1992, if you can believe it, has been over the word requirement. And in Chip Alone, where Congress itself wrote the warning label, the court said that it would be odd to hold a tobacco company liable for failing to add a warning that Congress itself did not write. And so there in Chip Alone, the court said the word requirement could, in some cases, include common law remedies under tort. And since then, there's been a series of decisions discussed in both my testimony and Mr. Cooper's testimony, in which the court has vacillated on what the word requirement meant. Finally, and Justice Stevens' concurrence makes this quite clear, finally in Regal, the court simply gives up the ghost and says going forward, the word requirement should be understood to include common law tort remedy. And
but what about, some of my colleagues made statements that they were here at the time, that wasn't the intent. Was that any of that information, they just ignored it or what?
Yes, the court just ignored it, and this is part of the court's new practice pushed by some of the justices on the court to look simply at the text of the statute and not to look at the statute's purpose or the underlying legislative history. The legislative history of the statute is quite clear. Congress did not mean to wipe away tort remedy for people injured by medical devices.
Okay.
And there's no argument on that score, I don't believe.
Oh, I appreciate that. I think it's important. Now, the device industry is arguing that a bill overturning the Regal decision like mine would dramatically change the legal and financial landscape for device companies. But would this bill really change the status quo? I mean, my understanding is that device companies face state tort suits right up until the Regal decision. So what's your opinion on that?
Right, I think that's true, though, with a caveat. Prior to Regal, the courts were divided on whether there was preemption of these kinds of cases. The majority of the federal circuits had ruled that there was preemption. None of these decisions, however, came before the mid-1990s. All of them are post-Chip Alone, post-1992 decisions. So none of the device manufacturers even argued preemption until post-Chip Alone. So it is true that in some jurisdictions and in many circuits, from maybe the mid-1990s through 2008, there was a preemption defense available to these kinds of devices. But if you look at the history of medical devices in the United States, they predate by decades the medical device amendments of 1976. We've had life-supporting and life-sustaining medical devices on the market for 50 or 60 years, and only in that one brief interval, that maybe 10 years, post-Chip Alone and pre-Regal, was there real preemption available. And even then, it was no guarantee because device manufacturers could be sued in some jurisdictions, including what some have colorfully referred to as the crazy 11th Circuit.
Well, let me ask you this. You heard some of my colleagues say that the most frequently repeated objection to my bill is that it will create 50 state FDAs and that devices will be regulated differently in different states. And then I think Mr. Cooper stated that products liability cases constitute a kind of regulation in disguise. I mean, what is your opinion about
I think that's an overstated argument. I mean, for every other consumer product, except where Congress has expressly preempted state tort law, we see parallel enforcement of state regulation, of federal regulation of products, and it's cars, cell phones, virtually any other consumer product that complements state tort law. They serve distinct functions, although they're somewhat overlapping. I think it's an overstatement to say that a state tort judgment is regulation in any meaningful sense. It isn't. It is not device specific. It doesn't tell the manufacturer that they must do anything. And for that reason, we have seen tort law and federal regulatory law coexist in virtually every sphere of government and private industry that we have in the United States. And this complementary role serves an important purpose. One is it compensates people injured through no fault of their own. And second, it deters excessive risk-taking. We can go up and down the list in terms of massive recalls of medical devices. And here, remember, most of these recalls are where, Mr. Cooper talked about who makes the decision about defect. Well, in virtually all of these cases, it's the manufacturer and the FDA. The Sprint Fidelis lead is being recalled because both agree it should be recalled. Bork-Shiley, heart valve, 55,000 people. The Sulcer heart valve, another 35,000 people. The Medtronic pacemakers. All of these products were recalled after serious defects emerged, and both the FDA and all of the experts there and the company agreed it was time to get the product off the market. That serves, in most of these instances, tort law served an incredibly important informational function. That is, we learned about the severity and pervasiveness of the defect through tort litigation, not through the imperfect adverse rewarding mechanisms that the FDA has.
Thank you, Professor. Thank you for your enthusiasm, too. The gentleman from Illinois, Mr. Shimkus.
As much as you don't want to go to me, no, thank you for the panel and compelling testimony. I left. One of the challenges of our jobs as member of Congress is we hear tough stories all the time, especially in the Health Subcommittee. I left here to go to this ALS lobbying day. I had folks in my office. So these are things we deal with on a daily basis, maybe multiple times. So we appreciate you all being here. Ms. Robb, can you give me the timeline? You were diagnosed, when the implantation occurred in 2005?
I was diagnosed in February of 2004, and the implantation was in May of 2005.
And what would have been your health condition had you not had the implantation?
The device was simply implanted as a safety net. It didn't do anything on a daily basis. I didn't use the pacemaker portion of it. It just was simply there in case I were to have a fatal arrhythmia to hopefully shock me out of it and save my life.
Right.
So I was on a course of medication that was increasing my heart function, and I was doing really well.
Yeah, good. I think that's helpful, and I appreciate that. Let me turn to Mr. Kinsley. I'm a St. Louis area member of Congress from Illinois. Of course, those of us who follow the St. Louis Cardinals are huge Jack Buck fans who was suffered from Parkinson's, and you would not have known that had you not seen him, and because his voice was still strong. When you moved from your chair, from where your seat was to Mr. Cooper's seat, had you not had the implantation, how long would that have taken you to do?
Well, it would have taken a few seconds longer, probably. I mean, I can't be more specific than that.
So the implantation for you has been pretty much, as you stated in your testimony, very helpful in obtaining a livelihood and your standard of living.
Yes, it's been essential, I would say.
In your testimony, you also talk about the problem of having two independent systems, the FDA and tort law, for making the decision on whether a device should be on the market. Can you talk about this and explain this analysis of the problem?
Well, you've got the FDA ruling, and you've got tort law essentially trying to do the exact same thing, which is to balance the risk against the benefit. And I was amazed to hear that well, let me start again. I think that surely tort law does draw a line under the behavior, affect the behavior of companies that manufacture devices. And any company that loses a case and then continues to manufacture the device anyway would do very badly both in the market and before this committee. That would be crazy. So I think it's undeniable that these are both systems that affect the decisions of medical device companies. And I think, in effect, the company does whatever is between the two is the most restrictive.
Thank you. Let me go to Mr. Cooper real quick. Does a patient have a right to sue the device company if it fails to follow FDA requirements in manufacturing the device?
Yes, the Regal decision following the Lord decision made it absolutely clear that states...
Let me go to the next one. That's fine. Does a patient have a right to sue if the device labeling is inconsistent with FDA requirements?
Yes, if the...
Okay, let me go to the next one. Does a patient have the right to sue if the company withholds data from the FDA?
Probably not.
Okay, does the patient have the right to sue if the company misleads the FDA as to the device's safety and effectiveness?
Same answer, but FDA has tools, including criminal prosecution, to deal with that kind of problem.
And I was going to follow up, Mr. Chairman, with just a question from Mr. Cooper. Can you expound on small business implications of this legislation?
Yeah, I'll give you an example. One of the areas that at least some years ago was grossly underserved was medical devices, including breathing instruments and the like, for prematurely born babies. That's a high litigation risk area. A company that develops a product, and there are some products, but a company that develops a product in that area is taking an enormous risk of litigation because nothing that humans make is perfect. Nothing in medicine is perfect. I'm not a doctor, but that's my understanding. Not medical devices, not drugs, not surgical procedures, not laboratory tests. Nothing is perfect. They all fail sometimes. And if you get failures in that area, you're going to get litigation and you're going to get enormous judgments. And small companies, that doesn't make sense. And that's where the innovation is, mostly, in small companies.
Thank you, Mr. Chairman. If I could ask unanimous consent to submit 2 letters, one from the Vietnam Veterans of America and also from Mr. Albert Dom, who's in a similar situation of the benefits of this, this type of technology.
Without objection, so ordered. Mr. Braley of Iowa.
Thank you, Mr. Chairman. One of the comments that was made earlier in the hearing was that preemption is not a get-out-of-jail card. Professor Vladeck, that's not true, is it? That's exactly what preemption is. It's a bar to the courthouse door.
It is.
And in fact, Justice Ginsburg mentioned that in the concluding paragraph of his dissent, where he writes, the court's broad reading of Section 360K, parens A, saves the manufacturer from any need to urge these defenses. Instead, regardless of the strength of a plaintiff's case, suits will be barred ab initio. That means before they're even filed.
Well, they'll be dismissed as soon as they're filed.
Exactly. And if this is a well-known legal doctrine, then people aren't going to take those cases and they're not going to file them.
That is correct.
One of the other comments was that this was going to dramatically increase the number of lawsuits against medical device companies, but until the Rayburn decision clarified this conflict within the circuit, there was nothing that prohibited somebody from pursuing this type of relief. So the same pace of claims is likely to occur whether or not this act is passed.
Right, which is why we're seeing so many cases dismissed in light of Regal.
Exactly. Now, one of the other comments that was made, I think it was by Ranking Member Barton, was quoting from the Republican Staff Committee brief. And he mentioned that this act, if passed, would severely disrupt innovation in the medical device industry that has existed since 1976. But you pointed out this same dual enforcement mechanism has existed literally since the act was passed. So any innovation that has been proceeding apace since 1976 should not in any way be affected by this.
That is correct, and even well prior to 1976. We had medical devices prior to Congress's passage of the medical device amendments.
Thank you. Mr. Kinsley, I want to ask you a little bit about what your concerns are specifically related to the role that tort liability litigation plays in medical device and pharmaceutical claims. Based upon your background, I assume that you are a firm believer in the Constitution.
Yes.
And that includes the Bill of Rights.
Oh, sure.
Which, as we know, includes the right to free speech and the right to freedom of the press,
Right.
which gives you the ability to do what you do for a living.
Right.
Are you a supporter of the 7th Amendment to the Bill of Rights?
Which one is that?
It's the one that says in suits at common law, where the value in controversy exceeds $20, the right to trial by jury shall be preserved. Do you believe in that amendment?
Well, it doesn't, it's not one that gets my heart beating faster.
Well, let's talk about that, because you understand the historical perspective that led to the passage of the Bill of Rights.
Well, let me say something about the Bill of Rights. I'm in the one industry that is protected from malpractice lawsuits, which are called libel suits in the world of the press. And the Supreme Court, as I'm sure you know, has said that because of the First Amendment, we are protected even when we have committed malpractice by making a mistake. New York Times against Sullivan. Every other industry does not have that advantage. This is just the opposite of most countries, such as in England, where journalists live in terror of lawsuits and everybody else is rather calm about it because they somehow or other manage to have a system that brings justice in most cases without a lot of the absurdities that, in my view, attach to product liability in this country.
Well, you understand that even journalists are subject to liability under certain circumstances when they engage in libel and slander, and there's differing degrees of proof whether you're a public figure or not. And that all factors into determining whether there is accountability. And in fact, some journalists have been held accountable because they took unreasonable risks with what they say about them.
Yes, you have to try really hard
Okay,
to
well
be
then,
sued.
let's talk about that, because one of the things that we know is if you are going to sue the manufacturer of a defective medical device, not anybody can do that. Did you realize that?
What do you mean?
Well, in order to bring that claim, you have to prove the manufacturer made a defective device that was unreasonably dangerous, that caused direct harm to someone, and even if you can prove that, and you're the device manufacturer, you have an absolute defense to those claims if you can prove that the product you introduced into the stream of commerce conformed to the state of the art at the time that product was manufactured.
Well, as I said at the beginning, I'm not an expert in this field, but I do think that as a general rule, our society is overly risk averse, and we pay for that.
But in this case, if you're the device manufacturer and this state-of-the-art is an affirmative defense that gives you complete immunity, you can walk into court and say, hey, the FDA pre-approved my product. That was the state-of-the-art at the time that product was introduced. That's my get-out-of-jail-free card.
Well, that seems like a good get-out-of-jail-free card.
And that exists
We're
right
going to
now.
have to, we're a minute over, so I know
Thank
you
you,
two are
Mr.
having
Chairman.
such a good time here that I didn't really want to stop you, but thank you. Mr. Burgess?
Thank you, Mr. Chairman. And I was enjoying that. It took me back 15 years ago when I was a physician in practice and every night would turn in Crossfire and watch you and Bob Novak go at each other, and I used to enjoy those exchanges as well. What concerns me today is I agree with you more than I recall agreeing with you 15 years ago. And I must admit, I guess things have changed in 15 years. Let me ask Dr. Kerfman, and I probably need to ask Dr. Meisel the same question. Both physicians, can you help us understand the physician's role in helping to evaluate and helping the patient understand the risks and benefits associated with any complex medical technology. That role does fall to the physician, does it not?
It is a common role for physicians to serve as counsel for patients when determining the risks and benefits of any therapy, whether it's a medical device, a drug, or some procedure. I think it's incumbent upon physicians to have accurate and timely information, and one of the things I as a physician have struggled with is dealing with medical device malfunctions with incomplete information, inaccurate information, or a lack of timely information in handling these cases.
And of course, we all rely upon the Food and Drug Administration to help us with those determinations. Do you ever find yourself in the course of clinical events reviewing court cases to find out if a device, if you should be counseling your patient based upon what's happened in the legal system?
I'm not sure I'm the right person to ask that question. I do review the court cases. I find them extremely interesting. I think there's a lot of very interesting information about device reliability that's in those court cases. I think a lot has been learned from those court cases, and there are things in those court cases that are released because of the court cases that otherwise wouldn't be released, including FDA documents.
Let me ask Professor Vladeck, you, in response to a question posed by Chairman Pallone about the 8-1 decision of the Supreme Court, was this consistent with what had been the decisions of lower courts, or did they depart from lower court decisions?
I think it's fair to say that many lower courts had reached the same conclusion that the Supreme Court did. I think it's also fair to say that there were many courts, particularly state courts, that did not. And so you had a deep division within our judicial system about the proper reading of the preemption provision of the medical device amendments.
But it was not inconsistent with what the lower courts had ruled. So in that aspect, did not alter the regulatory environment.
Well, remember, no court had ruled that there was preemption under the medical device amendments until the mid-1990s. And so to the extent there was preemption during this period, one is it was recent, and second, it was incomplete, because plaintiffs could engage in forum shopping, and where possible, they'd sue in the jurisdictions that permitted these cases to go forward. So it is not as though prior to Regal, any medical device manufacturer had an assurance that a claim would be preempted.
And who would engage in the forum shopping?
The plaintiffs, yes.
Yeah. Yeah,
it's only bad when the other side does it.
Well, Mr. Cooper, let me ask you a question, if I could. Some suggestion that the effect of the Regal decision is to provide broad-based immunity in instances where the medical device failed, the get-out-of-jail-free card versus don't get out of jail free. So would you agree with that? Do you think that is true?
No, I would not agree with it, Mr. Burgess. The Regal decision applies only to devices that have gone through the PMA approval process. That's about 30 products a year, less than 1% of all the devices on the market.
Under current law, does the patient have the right to sue the manufacturer if the device fails?
People can always sue. Whether they'll win is another matter. And if a manufacturer has, as I discussed earlier in answering some questions, if a manufacturer fails to comply with FDA requirements in the conditions on the PMA approval or the manufacturing process, Regal would not provide any defense. The real problem I think we're grappling with here is that medical devices are going to fail even if they are the best that human beings can make. And how do we take care of the people in whom they fail or for whom they fail? And that's a matter of health insurance or disability insurance or life insurance. It's an insurance system, and the product's liability system is not intended to be an insurance system. It's based on fault or defect. And if the product isn't defective, if the manufacturer is not at fault, then the plaintiff should lose. That's our legal system.
Let me, in just the brief time I don't have left, if on the physician's part, the physician utilizing the device, if they commit an error either in diagnostics or application of the device under Regal, can they be sued?
Yes. And in Levine, for example, the doctor, the clinic, I guess it was, settled. And if you look at the facts in the Regal case, the physician who was applying the catheter, the balloon catheter, misapplied it in violation of the labeling. Nevertheless, plaintiff sued the device manufacturer.
Okay, we're going to move on. Thanks. Gentlewoman from Florida, Ms. Castor.
Thank you, Mr. Chairman. Thank you all very much for being here today. Some device companies have argued that the pre-market, or that the impact of the Regal decision is limited numerically because it only applies to PMA devices. Mr. Cooper just made the argument that it only represents 1% of all medical devices reviewed by the FDA. But is this a fair representation of Regal and all of the devices, Dr. Maisel? Does that 1% figure accurately represent the actual usage and importance of PMA devices?
The best term I can come up with to describe that number is propaganda. The repeated use of the 1% or we've heard 2% number is fuzzy math. The devices that we care about are not tongue depressors and bedpans and stethoscopes, which are included in the 99%. We care about the important life-sustaining devices whose safety patients rely on. And those devices, we've also heard a number of approximately 30 new PMA applications a year. Well, the FDA actually sees over 1,000 PMA and PMA supplement applications each year. So it's much higher than that number. And if you think about the number of patients affected by these devices, it's in the millions. There are more than 10 million Americans living with permanent implanted devices right now, and there are hundreds of thousands, if not millions, implanted each year.
And what type of injuries and what type of patients?
Well, these devices are, in many cases, are life-sustaining devices. We've heard from a patient today here on our witness stand that received painful shocks. There are devices that can fail to deliver life-sustaining therapy when needed. There are pumps that can under-deliver or over-deliver medication. There are stents that can malfunction. Every product has the potential to malfunction. And I'd like to just clarify, I agree. I don't think a malfunction should equal liability for a manufacturer. That's not what we're talking about here. We're talking about a manufacturer that fails to meet the standard of care, that fails to produce a product that's as reliable as it should be.
And Professor Vladeck, it's unclear to me, does the preemption apply even when the corporation or folks in the company knew or had knowledge that the device was defective even after they received the FDA approval? So, Mr. Kinsley, I'd ask you, what about those cases when folks in the corporation or the corporation or personnel knew of the danger? Does it make sense that consumers are barred from seeking compensation for their injuries and lost wages?
When you say knew of the danger, if this company has met FDA standards, and what they knew was that there's something, either it meets the standards or it doesn't. And if it meets FDA standards, then you shouldn't have to meet a whole nother
But even if they knew that the device was faulty and could cause injuries, you're saying that if FDA signed off on their...
presumably what they knew was Well, if what they knew was that the device didn't meet FDA standards, yes, of course, they should
But
be
what,
liable.
I think the case is that they receive the pre-market approval, and approval from the FDA that is supposed to mean something, but they had, even in the cases, they had knowledge that the device could cause injury.
Well, I think some things I've heard today and things I knew even before suggest, and I think everyone here agrees, that the FDA could use a little bit of improvement. But
Well, it would seem to me that the companies in those,
Well,
in that case, have a responsibility to be truthful in the FDA process.
Well,
The FDA
sure,
pre-market
I would
approval
say
isn't
if the company is
blessing.
lying, even if it's lying about a product that does meet FDA standards, that's not good. And they should maybe lose this immunity they get.
Thank you very much.
Thank you. Gentleman from Indiana, Mr. Boyer.
Mr. Kinsley, I will be your lifeline. Okay?
Thank you.
I will be your lifeline because I disagree with the professor's testimony. The professor's testimony said that federal preemption will give protection to a manufacturer if, in fact, they voluntarily withhold information, i.e., that's wrongful conduct, or lying, that's wrongful conduct. So if a corporation is involved in wrongful conduct, they are outside of the federal preemption, as according to the Supreme Court decision. Isn't that not correct, Professor?
The decision I was referring to.
Wait. Is my analysis not yet? Is that not correct?
I believe it.
First, Professor, do you have the mic on?
I do.
All right, go ahead.
That analysis
I
I
believe
gave,
it's
Professor.
incorrect under the Supreme Court's prior ruling.
Professor, time out. The analysis that I just gave, according to Regal, is that not yet correct?
Preceding Regal is Buckman. Every lower court to address what I believe is the question you're posing has said that that is essentially a fraud on the FDA claim, which is preempted. And maybe I misunderstood your question, but
it is clear, I believe, it is clear after Regal that if a manufacturer of a PMA device, in fact, commits wrongful conduct, it can be held liable. That's my lifeline to you, sir. That if somebody is lying, they voluntarily withhold that information, you do not get the shelter of the law. If you participate in wrongful or criminal or conduct that will be harmful to our society, you don't get the shield of the law. That's Regal, is it not?
I would hope you were right. Let me just make two caveats. With all respect, I think the lower courts have not read Regal to overrule or to in any way affect Buckman. And if you look at the cases cited at footnote 25 of my testimony, many of them discuss precisely that issue. I would agree with Mr. Cooper that the sanction that would be available would be the FDA bringing an enforcement action against the company. And the FDA plainly would have the authority to go after the company for doing that conduct and could proceed criminally. So I'm sorry.
Is your background in tort law?
I've done tort law, yes, sir.
Under products liability law, help me, I'm just a country lawyer. So under products liability law, a device manufacturer's liability must be based on some type of fault. Is that not true?
That's correct.
Some type of fault. So if a manufacturer, though, abides by the rules, the regulations, the procedures, the law, where are they then at fault?
They're not at fault.
And that, in fact, is the importance of the preemption, the shield to that manufacturer in the pre-market approval process, correct?
I think I understand you, yes.
Yeah. And so that's basically, that's why I'm saying, all right, the Supreme Court, I understand why you then have made that as a ruling, to bring clarity then to all of the other courts and jurisdictions around the country accepting the hiccup.
Well, and many state courts. You're correct that only the 11th Circuit in the federal courts.
I'm referring to the federal courts.
Okay.
And you would agree with that?
I'm sorry?
And you would agree with that? What I just said with regard to there's one circuit that was out of balance with the other.
Right, that is correct.
Okay. So back to my lifeline to you. I mean, I just want to be really clear here that if, in fact, there's a manufacturer, Mr. Kinsley, that in fact has lied, they don't get the protection of the law. And I don't think any good manufacturer out there wants there to be protection against anyone who's not playing by the rules. If they play outside the foul lines, they should feel the full wrath of the law. Would you not agree?
Thank you for that lifeline.
I just don't remember that on Crossfire. I don't remember that. Here's the other point that I had to make in my opening, and it really does concern me because in the 17 years I've been up here, I've been a strong advocate of our country being able to attract great minds from all over the world to come to the marketplace, at-risk capital, push the bounds of science to the benefit of our society and then unto the world. If, in fact, we pass a law like this, what are the consequences? Let me turn to you, Mr. Cooper. What are the consequences going to be upon not only innovation, but will there be a quilt, sort of a patchwork in the marketplace with regard to where manufacturers are going to go to sell their products for fear that one state may, in fact, have a different litigious environment?
Well, there may well be some of that. I think the major impact would be lack of development of products where there is great need, but also great liability risk. I think the experience of lawyers who try products liability cases is that juries will do what they need to do to compensate an injured plaintiff. If they even if the manufacturer had a warning that said, don't do this, it will kill you, the jury will find that that was inadequate because it could have said it will kill you for sure. And that's a natural human reaction. And it's a problem. And the effect of it is on people who need medical devices, and they're not there, or they haven't been improved to the extent that they could be if more investment were made, but the manufacturers decided to put the investment somewhere else, which presents less liability risk.
Thank you. Thank you, Professor.
Thank you. The gentleman from Utah, Mr. Matheson.
Thank you, Mr. Chairman. I think this topic is certainly an important issue. It represents an intersection of a number of key dynamics, including patient safety and health care and innovation. And while we all agree that patient safety should be a top priority, I think we'd probably all agree that if a device maker has done something wrong, they should be held accountable. But what I'm concerned about is that a blanket approach could have some far-reaching consequences. If the problem lies elsewhere, say with the review process at FDA,